I'm going to call the sixth meeting of the Rhode Island Ethics Commission to order. It's properly noticed for April 8th, 2025. We have 7 members in attendance, I believe, or soon to be 7 members in attendance, so we have a quorum. And the first item on the agenda this morning is the administration of oath of office to Major General Christopher P. Callahan, retired.
Sir,
I will.
sorry.
Take him one. Council, knock him down first. Would you please raise your right hand and repeat after me? I.
Christopher Callahan. No,
I,
Christopher Callahan,
having been duly appointed by His Honor Governor Daniel J. McKee,
having been duly appointed by His Governor Daniel J. McKee,
swear to uphold the duties and responsibilities
swear to uphold the duties and responsibilities
of Commissioner of the Rhode Island Ethics Commission
of Commissioner of the Rhode Island Ethics Commission,
as enumerated in the state constitution,
as enumerated in the state constitution,
the laws and regulations of this state and of this commission,
the laws of this state and this commission,
and regulations of this commission,
and regulations of this commission,
as enumerated, and further to abide by my own conscience, independence, and integrity
and further to abide by my own conscience, independence, and integrity
in fulfilling these duties, so help me God.
in fulfilling these duties.
Thanks. Right. Next item on the agenda is a motion to approve the minutes of the open session held on March 25, 2025. May I hear a motion, please?
So moved.
Motion by Commissioner Rabideau, second by Commissioner Browner. Roll call vote, Commissioner Susie.
Aye.
Commissioner Browner.
Aye.
Commissioner Centerini.
Aye.
Commissioner Callahan, I assume you will abstain.
That's true.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. The next item is the director's report.
Hey, good morning. So first I'll just mention for the record, I guess, that we are live streaming our open session today. And the link to the live stream is available on our website. It's also in the agenda. The materials for today's meeting, particularly the draft advisory opinions, are all available also on our website for anyone who is accessing the live stream. And we'll stay in the live stream all through open session to get through the advisory opinions today. Then we will break into executive session, which is a closed session. And at that point, the live stream will end while we handle that business in executive session. Once we come out of executive session, we'll reopen the live stream in the open session. The first thing that will happen is the chair will report out any votes that were taken in executive session. And those votes are also put into writing and are available on our website. Let's see, so just to go through on the director's report regarding complaints and investigations, we still have 3 complaints pending right now. There's really no changes to any of these. Torsen complaint is still discovery ongoing. Today we have a probable cause hearing in the Heidi Weston Rogers complaint. And we are investigating in the Jason, the charge. Regarding advisory opinions, you remember at the last meeting, we had 19 pending. They're just coming in so fast right now. For some reason. Today we have 15 pending. So today, and we have 6 on today's agenda. So if we get through those 6, we'll be back down to single digits, which is a nice thing for us. We had 2 APRA requests since the last meeting, which is not a lot for us. We always try to complete our APRA requests within 1 business day here at the Ethics Commission instead of the 10 that we allowed. We were able to do that with 1 of those advisory opinions. The other one was a request for some old financial disclosures that we keep offsite in storage. And so for those, we estimated that it would cost about $27 to retrieve and copy those older financial disclosures, and we're waiting for the requester to tell us whether he wants to pay the $27. So the time limit is told for 30 days until we hear back from that person. Just briefly on financial disclosure, as you all know, the 2024 statements are due April 25th of this year. Commissioners who haven't filed yet, you know who you are. So, and I know who you are. So I was finally able to file mine just in the last week. It wasn't too difficult. So I'll keep on you about those. We have, as of this morning, almost 2,200 filers. And again, we process every one of these, even though most of these are online. Even online, there's a human being that has to handle some of this processing. So it keeps us quite busy. Then just general office administration matters. Our next meeting will be April 29th this month. So we've got a few weeks before the next meeting. I also just want to mention regarding the common cause petition that's on today's agenda. As you know, we just keep that on the agenda, so we don't ever forget about it until we've done something one way or the other. However, and I've already advised the chair, the executive director of Common Cause, John Marion, had let me know well in advance that he couldn't be available for today's meeting. And so I'm suggesting that we just pass that off of today's agenda and we'll hit it on the next meeting on April 29th. So he'll be back. I should have my research back to you by that time, hopefully both on the issue of other states that regulate lobbyist gifts and also as to the dollar amounts of gifts in some of these other states. So we'll deal with that when we get to that on the agenda. That's just my recommendation. Finally, something new in the director's report that might take a little bit more time than in the director's report than is normal is today we have a legislative update. Just to give you some background, part of my responsibilities here, executive director, is that I monitor all the legislation that gets introduced in the House and Senate each year. And I'm looking for any bills that might impact either the Ethics Commission or the Code of Ethics or commissioners in any way. And when I find them, I bring those bills before you in a legislative update, explain them to you, give you copies of those bills. And generally, I'll make a recommendation to you as to how we might want to handle it. I'm also the commission registered lobbyist. So apropos to the lobbyist disclosure, I am a registered lobbyist just for you. And so not for anyone else, and only on issues relating to ethics and the Ethics Commission. And so part of my responsibilities are if a matter gets scheduled for a legislative hearing, as is one of these for tonight, I will go to that hearing. If indicated, I don't go to every hearing, but sometimes I do. And tonight I suggest that I will, to testify consistent with the directions that you give. So I'll make a recommendation as to maybe what the testimony might look like, but ultimately you'll decide whether you want to support legislation, oppose legislation, or quite often, sometimes just take a neutral stance, but provide information so that the legislators at least know what they're looking at and what they're doing. So with that said, I want to talk a little bit about these two bills that have been introduced. I think I'll stand up and do that. It makes me more comfortable. That's okay.
No.
So why don't we begin by discussing the bill that was introduced in the Senate. This is Senate 927. And this is a bill that would add a statutory gift law to the Code of Ethics. As you know, we already have a gift rule in the Code of Ethics, but it is a regulatory gift rule. The Ethics Commission in 2005 enacted the gift rule on its own without legislative input or approval, as we are allowed to do, as you are allowed to do. And I'll explain that a little bit more in a moment. That gift rule is the rule that says that a public official or employee can't accept a gift worth more than $25 from an interested person, up to $75 in the aggregate from that same person. So multiple gifts. So for instance, I get three $25 gifts from one of my staff attorneys. They're all interested in my decision making, so they count. I can do that 3 times. I don't do that, but under the gift rule, I could. So what the Senate has introduced, Senator Chacon is the lead sponsor, and then there are several sponsors behind it. It looks like both Democrats and Republicans. He's introduced legislation that would copy most of our gift rule, but not all of it. Interestingly, they didn't put any of the exceptions in, which in itself is a problem, but most of the gift rule and except they raised the gift limits. So the gift limits that this bill is proposing is gifts worth more than $50 would be prohibited, but 50 or less would be okay, up to an aggregate of, was it $250? So instead of doubling that, they raised that quite a bit more. So again, that's pretty much what it does. What they didn't include are any of the 7 exceptions that we have in our own gift rule, which is exceptions for campaign contributions, for services to assist an official in a public official in their duties, a plaque or similar item in recognition of services in the field, a gift given because of your membership in a group, and every member of that group gets a similar gift. So think like you go to a convention for the bar association or for adjutant generals, or whatever the case might be, and everyone gets a similar gift. Exception for gifts from family members, exceptions when you return the gift immediately, exceptions for taking the gift and giving it to a bona fide charity organization. Those are all missing. Now, to get to what I view as a couple of the issues that I see with this legislation, some are technical and some are constitutional, frankly. So the technical problems are what I've mentioned about the fact that it doesn't have exceptions. There's also the problem that it's adding a couple of new definitions into our definitions section of 3614(2) of the general laws. But instead of putting them at the end, it sticks them right in the middle, which means it changes the order of all of our other definitions. And there are numerous statutes that refer to these definitions by subsection. So all of those would need to be changed also. That's fixable, but it's sloppy drafting. And it's something that we want to try to avoid. The major issue that I see with this is that the General Assembly is not allowed under the Constitution. It's not allowed. It can't change the gift limits that the Ethics Commission has established. And that is a somewhat controversial statement to make if you haven't followed the history of the ethics amendment to the Rhode Island Constitution. And I don't want to spend a half an hour giving you a history lesson on it, but I will spend a couple of minutes just to tell you that the Ethics Commission was created by a constitutional amendment in 1986, amended the Rhode Island Constitution to create the Ethics Commission, and it said that the Ethics Commission shall adopt the Code of Ethics. What does that mean? Well, we found out what it meant in the early 90s. The Ethics Commission decided, hey, I think that means that we don't have to get legislative approval to come up with new provisions in the Code of Ethics, to make new ethics laws. So they announced we're about to pass 2 revolving door provisions of the Code of Ethics. And fair warning, we're doing it. And Governor Sunderland said, okay, I don't think you can do that. So he asked for an advisory opinion from the Rhode Island Supreme Court. And he asked 3 questions, but in a nutshell, they were, can the Ethics Commission legislate ethics laws? Is that allowed? And then number 2, if they can legislate ethics laws, does that mean that the General Assembly can't legislate ethics laws? And then finally, if the answer to both of those are yes, or either of those, is that constitutional? Does that violate separation of powers, the guarantee clause? And the Supreme Court issued an opinion in 1992. It's called In Re Advisory Opinion to the Governor. And it is the greatest opinion for the Ethics Commission that you can imagine. I mean, I couldn't have written it any more favorably for the Ethics Commission. It is a masterpiece of good news for the Ethics Commission. It lays out the entire history of how the commission was created and all of the scandal and corruption that was present at that time, leading the people to want to make a change. And the court said, yes, adopt a code of ethics means the Ethics Commission has legislative power. Yes, it's an administrative agency, but we're going to take a little bit of legislative power from the General Assembly, just a small amount, just relating to substantive ethics laws. We're going to give that to the Ethics Commission. And so then the question is, well, is it just the Ethics Commission, or does the General Assembly still have the authority to enact substantive ethics laws? And the court said, no, it's a concurrent legislative authority. The Ethics Commission can do it, and the General Assembly can do it. However, if there's ever a situation where a regulation passed by the Ethics Commission and a statute passed by the General Assembly conflict, if first we're really going to try and reconcile them and make them both work. If it's at all possible, we're going to try and have them both work. But if we just can't do it, the Ethics Commission wins, which is, as far as I know, the only situation where that applies in the universe. I don't think there's any other administrative agency that has the power to enact substantive ethics laws that are primary to the laws enacted by the legislature. I could be wrong, never seen it anywhere else. It's just another reason why Rhode Island is Rhode Island. So,
Jason, is there in fact another ethics commission that has constitutional basis?
there are. We were one of the first. Hawaii, really, I think Hawaii beat us to it. And a lot of our ethics rules and our constitutional language came from Hawaii. So it's nice, one island, another island. And some have enacted some constitutional change since then. I think New Mexico now has it in their constitution, and maybe Colorado also. So, so it's quite remarkable. So now, of course, we want to remember that it is an advisory opinion, right? It's not a case in controversy case, so it doesn't line up, doesn't have quite the same precedential value that it would have had if it would have been someone suing us and claiming we didn't have constitutional authority. But it's such a wonderful opinion, and it's held up for a long time, and it's great. So what's that mean for this? Well, here's a situation where the Ethics Commission has enacted the gift rule, and we've said the limit is $25. So we occupy the field of gifts. You know, we're very clear about that. So for the General Assembly now to pass an almost identical statute where the only real difference is changing the dollar amount, if that were to be enacted, then there would be one rule that says $25 limit, one rule that says $50 limit. Under the reasoning of the 1992 advisory opinion, the Ethics Commission's rule is primary to that. And so we would just continue to enforce the gift rule at the $25 limit rather than the $50. I don't really want to march up to the Senate and give that speech tonight. Certainly not quite the same, but I do think, and I'm not convinced that it's even necessary. It may well be that the sponsors are aware that the Ethics Commission is looking into this. I certainly have. I go up to the Senate and the House each year, and I give ethics training, and this topic comes up. When are you guys going to raise the gift limits? Isn't it time? It's 20 years now. Certainly 25 is worth more today than it was in 2005. And I've told them, I think, you know, we might be reaching the point where the commission is willing to give it some serious consideration. And certainly you are. You've already publicly stated that we're going to, this summer, look into the gift limits and consider raising them. And part of what you've tasked me to do is to look at other states and see what the gift limits are in other states. So that process has begun. I think that if we go, if I go to the hearing tonight and let the committee know that what you were doing and that we're looking at it, and that, you know, our position is that it's both legally correct and just as a matter of common sense, that the Ethics Commission is the appropriate agency to look into this. And why don't you put a little faith in the Ethics Commission to really do the right thing and study it and ask for public comment and make a decision. And after all, it's not an emergency to change the gift rules. You know, there's plenty of time to see how you all handle it. And if they don't like it, there's always next year. So my recommendation on this one is that I attend tonight's hearing in a very courteous and gentle way, providing that kind of information without necessarily even signing in as opposed or in favor of the legislation, just showing up, signing in, and answering questions that they have, giving that kind of information.
Mr. Chairman,
Open discussion, please.
Mr. Chairman, I think it would be important to clarify when you testify tonight. We're neck deep into consideration about the gift rule. I mean, we've had some interesting hearings. We haven't decided to go forward with the rulemaking process, but I think the commission has demonstrated great goodwill on this matter historically for the last few months. And I would hope that we could complete our process without entering into a constitutional opposition with the General Assembly. So I think they should know how many sessions we've had, how lengthy discussions we've had, and this is all coming to a fruition for significant votes within a matter of weeks, months.
Any other?
Yeah,
comments?
I guess also that changing the definition of interested person, or they're adding a definition of interested person, which we're dealing with right now with common cause. So it should be made aware.
Yes, absolutely.
Though that one doesn't attempt to capture what Common Cause is trying to capture.
No.
Interested person. It doesn't bring lobbyists into the fold.
Right.
This is much more consistent with our interested person problem already. Any other comments, questions?
The other thing, just for consideration, the gift rule was established more than 20 years ago. What is ballpark the current monetary worth today of the $25-75?
I have an answer to that. Okay. I looked it up. So, you know, the good old internet. So you can find out what the rate of inflation is over a certain period of time, and the best site that I found, although they all agree, so they're all within 50 cents of each other, is the U.S. Bureau of Labor Statistics that bases the rate of inflation on the Consumer Price Index. And you can put in what was $25 worth of buying power in 2005. What is it in 2025? Anyone want to guess?
75.
That's about where I thought it might be. I was surprised to find out that it's $41. So something that cost $25 in 2005 costs $41 today. So, you know, 50 is not exactly out of the ballpark of that. And I suppose if and when a change is made to that, you might want the change to be a little bit more than where you are, so that You don't have to come back every year and see what the rate of inflation is again. You know, maybe we could get another 20 years out of it. 50 or, 45 or whatever, whatever it is that you come up with if you decide to come. Okay.
Was there a sort of a background as to why those original numbers were created? You know, one threat being they are gift oriented and they're at a level that is somewhat suggested that they wouldn't sway an opinion or something. Was there any level?
It's a perfect question. It's great. So I can give you an anecdotal answer as someone who was there and who actually was staffing that rule change before the Ethics Commission in 2005. So what I saw was initially the gift rule had been, when it first went into effect around 2000, it was zero. You may not accept a gift of any value from an interested person, zero. And the problem was with the regulated community, they just thought it was ridiculous. You know, suddenly you can't have a bottle of water or a turkey sandwich for a working lunch, or if you're marching in a parade, you can't put on a baseball cap. So the commission went into rulemaking, and this was around 2002, 2003, maybe 2002. Or even earlier, maybe it was 2001, but very shortly after the zero tolerance went into effect, the commission came back and held hearings of rulemaking and changed it to $150. So they went way the other direction. You can accept gifts worth up to $150 and up to $450 in the aggregate. Well, the regulated community was very happy, but the good government groups and the public were not at all. And there was actually quite a bit of turbulence created by that, including even lawsuits and allegations that commission members, were favoring lobbyists and things like that. And so the commission went back into rulemaking. This is now 2005. And we went back into it, and there was no magic to the $25 number, but what the commission was looking for was a number that would allow for these small items to go unchallenged and not bog down the work of the Ethics Commission, having 6-month investigations over turkey sandwiches, coffee cups, and baseball caps and t-shirts. $25 in 2005 seemed like the right amount. We did have people testify. We had public workshops. And that's what the commission came up with. And from my perspective, and I think from the staff's perspective, $25 has worked so well over the last 20 years. It's very rare to have frivolous gift cases filed with the Ethics Commission. The gift cases that we do get are, it's Mayor Moreau getting a $7,000 boiler installed in his house for free. It's, that fancy deals and things like that from people who have a real financial interest in the decision making. So having a low limit has to me has been very, very good. And I wouldn't want to see it raised too much, but maybe 25 is too low in 2025.
Any other questions or comments? On this particular kind of problem, I think what I'd like to do is see if we have a consensus to allow Mr. Grammett to go and make the representation on this bill that he's discussed. Is that acceptable rather than motion process? Is there anybody who would object to Mr. Grammett going and making the presentation he's discussed? You have our authority on that.
Fantastic. And just as a matter of checks and balances, you're curious as to how it goes tonight or tomorrow or next month, you can go on Capitol Television and pull up the live stream and you'll be able to see exactly what was said and how. Feel free. It's not the best television out there, but you might like it. So that's that bill. Thank you very much. The next bill is one that is in the House. It has not been scheduled for any hearings yet. Both of these were just introduced just within the last week. In the House, it's House Bill 6166, introduced by Representatives Tansey and Agello. This one was referred to House State Government and Elections, which is a lot of our bills end up going to judiciary, but this one went differently. So this is a interesting one. This is a bill that would create a new law to address the issue of sexual harassment committed by legislators, any employees of the General Assembly, including volunteers, interns, and pages, and also lobbyists. So, under this bill, if it passed, complaints of sexual harassment would be made to the Ethics Commission. The Ethics Commission would be tasked with investigating the allegations and adjudicating the violations. And if the commission finds a violation, would be given the authority to take remedial action, ranging from warnings and reprimands to withholding pay, reassigning people to other duties, suspending them without pay, or even termination or other punishment deemed appropriate by the Ethics Commission. So pretty open-ended. I will just give my general sense of this legislation, and that is that it's a very serious issue, first of all. And as someone who works with a nationwide and international group of ethics enforcement officials, know that when the Me Too movement was happening, there were states that considered giving this type of enforcement over to ethics commissions, because after all, sexual harassment is unethical, right? We can all agree to that. And so I think that's where this comes from. Also, a lot of ethics commissions are already set up to handle investigations and adjudications and enforcement matters and things like that. Nevertheless, I think the general consensus in the ethics enforcement community has always been that this is so far outside the wheelhouse of what ethics commissions do, and that we're not really trained for it, and that these types of investigations probably require significant training and sensitivity issues to deal with victims of sexual abuse, sexual harassment. I mean, there's a reason police departments have special victims units, you know, so, you know, my feeling is that absent, you know, a big infusion of funds and training and a lot more details, I don't think it's a good fit right away. I'm not sure that it was intended to. You know, sometimes you don't know when a bill is introduced if it's meant to just start a conversation or a discussion and see where it goes. I think that there are agencies that are probably better suited in the state to handle this. For instance, the Human Rights Commission. It is a state agency that handles discrimination cases, and they're set up very similar to the Ethics Commission. They already have investigators, they already have enforcement authority. And I have spoken to some legislative leadership, and that seems to be the consensus that if this were to go forward, it would probably go forward in a different agency than the Ethics Commission. So my suggestion, and of course I want to my suggestion is that we just take a wait and see attitude with this. My sense is that it's not a legislative priority this year. I don't know that we even need, it hasn't been scheduled for a hearing yet. It will eventually. I'm not certain that we need to even go to that meeting and testify at all. You know, the first time something comes up for a committee hearing, it's usually just there for a hearing and not for consideration. So the way these hearings normally start is the first thing that happens is there's a vote to just hold everything for further study. And then then you can judge after that whether this thing really has any momentum. If it does, there are other opportunities to testify. If this thing passed the House, it would have to go to the Senate. We can testify at the Senate hearing. We can reach out to the sponsors at some point. We can reach out to leadership. So my suggestion for now is that I keep a close eye on it. and let you know of how this continues to progress.
Comments, questions?
At first blush, and, you know, not with any great consideration, I would express the reservation that the legislation appears to conflict with the state constitution. The state constitution, which established the Code of Ethics and the Ethics Commission, addresses public employees and public officials. But when now you get into volunteers, I don't know if an intern falls within that constitutional definition. Lobbyists obviously don't. I think that there's a constitutional issue there that should be explored. Mr. Chairman, members of the committee.
Other comments? I want to add on to that, but just, so my question is how it could possibly be constitutional without redefining ethics violation to include such an act? There's nothing in here that says that this is an ethical violation. Our job is to deal with ethics, isn't it? You can call it an ethical issue, but right now we have certain constitutional authority to deal with ethics complaint. I don't see this as, at least starting out, as an ethics complaint at all. So I have real doubts, Commissioner Santorini, about the constitutionality of it, but I would agree with you that right now, this is one of those bills that has that feel of let's throw it up the flagpole and see what happens. And I said, let's see what happens. Anybody else have a comment? Is there a consensus to Mr. Graham with the instructions to proceed as he has suggested?
Can I ask for clarification, please? What happens if there's a scheduled hearing in between commission meetings? He hasn't been authorized to do anything per se.
So your suggestion would be that beyond that, we authorize Mr. Graham to attend hearings as they may come up
If they are between,
between meetings.
Yeah.
And to act consistent with our discussion.
yes,
Everybody okay with that? Sure. Any opposed? Any opposed? You have the consensus agreement of the commission to proceed as you suggested with the comments from Commissioner Senator.
Great, I appreciate that. Sometimes things do come up between meetings and, you know, if something like that happened and I wasn't sure, didn't have a good sense of where the commission stood, I would always consult with the chair before taking any action. And of course, the accountability is always if I go out and mess up, well, you know, you can let me know. So that's all I have on the legislative update, unless you have any more questions about any of that. And that concludes the director's report. Thank you.
Robbie, give our director's report this morning. All right, the next item on the agenda are advisory opinions, and the first sign up on the sheet is Jane Duran.
Mr. Chairman, before we begin, I filed a recusal form on all of the matters that deal one way or another with Barnet Shores. It's my understanding that since all matters are going to be considered in open session on today's agenda, I am allowed to remain in the room, but in the gallery. I don't have to leave the room. Thank you.
Thank you for that, Commissioner.
Good morning, Commissioners. Good morning, Ms. Duran. This draft advisory opinion is in the top A in your binders. Ms. Duran and the next three petitioners on the sign-in sheet are all members of the Barnet Shores Fire District Council. Their requests stem from the same matter, specifically the Fire District Council's review, discussion, and decision-making relative to potential changes to the Fire District's charter and its definition regarding who can vote in the district. The Fire District is a quasi-municipal agency that was incorporated by an act of the General Assembly in 1932. The fire district is governed by the fire district council. The petitioner was elected to the council in August of 2024. You may be aware that the question who is eligible to vote in the district has been a hot topic in the recent years. The petitioner represents that there have been multiple litigations against the fire district relative to that matter. The initial lawsuit challenged both the exclusion from the voting roll of non-property owning residents, or those are the renters, and the inclusion in the voting rolls of beach club condominium owners. Now, as a background, the beach club is a private condominium association that is located in the fire district's community and consists of 930 privately owned condominiums units available for seasonal use. The majority of those units are non-residential bathhouses, and none of those units are year-round residences. All beach club unit owners are considered to be property owners, and because they're property owners in the fire district, currently they are allowed to vote in the fire district. The lawsuit concluded in 2022 with a Superior Court decision and consent judgment that extended the voting franchise to include all permanent Bonnet Shores District, Fire District residents, and including non-property owning renters. The presiding justice did not make any other changes and did not exclude the beach club owners from the voting franchise. The fire district, however, was required to create a charter review committee, which would review the charter and make any proposed recommendations for changes to the charter and the voting franchise. In January of 2025, Ms. Duran was appointed to that committee, and she's currently serving as its vice chairperson. She represents that the charter committee is advisory in nature. The charter committee met 6 times and provided 4 proposals to the fire district council. I have laid out those proposals on pages 2 and 3 of the draft. Those proposals are identified as scenarios 1, 3, 4, and 5. My understanding is that there were more proposals that were rejected early in the process, and that's why the numbering is a little off. There's no scenario 2. The petitioner describes the charter amendment process as follows. The charter committee makes recommendations or changes to the charter and the voting franchise. Those recommendations are sent to the fire district council. The fire district council reviews them. If they would like to accept any of the changes, they may vote, and then they may vote on a resolution to ask the General Assembly to enact an enabling legislation that would authorize the fire district to hold an election to allow the district voters to decide whether or not to accept or reject any changes to the charter and amendments to the voting rights. The petitioner represents that she does not reside in the district, but she owns a residential property there and a bathhouse at the beach club. The petitioner states that several family members, while not residing in the fire district, also own property there. On Friday, I reached out to the petitioner to discuss today's hearing and the draft, and she noted that she needed to clarify the ownership interest of the family members. The clarification does not change the analysis or the outcome of the staff's recommendation. However, it requires me to change some of the language in the draft. You don't have those amendments in the drafts before you because those were made afterwards, after you've already received the packets. However, after I do the presentation, I can go over each of the amendments in specifics. The petitioner clarified that her brother owns 2 homes in the fire district. Her niece and her nephew jointly own a home in the fire district. And most significantly, her sister, her niece and her nephew jointly own a bathhouse condominium unit at the beach club. That's the main difference that I had to adjust the language in the draft. The beach club condominium owners have been notified that in addition to their regular annual assessment fees, this year the beach club has assessed each beach club unit a special fee to be used as necessary to contribute to the cost associated with potential legal expenses to protect the Bonnet Shores Fire District voting rights of beach club owners. The petitioner and her family members are required to pay those additional fees. They don't have a choice to not pay them in order to keep their accounts current and to avoid any liens being placed on their bathhouse units. The petitioner states that there is currently no such litigation pending and that any future legal action is hypothetical at this time and it will depend on whether or not any changes to the voting rights are made. Given this set of facts, the petitioner seeks guidance from the Ethics Commission regarding whether she may participate in council's discussions and decision-making relative to the proposed amendments to the charter and its definition as to who is eligible to vote in the district. Given first that she has participated in those discussions as a charter committee member, and second, given that she is required and her family members also are required to pay those special assessments to the beach club. Under the Code of Ethics, a public official, as you know, may not participate in any matter if it is reasonably foreseeable that any person within her family, her business associate, or a business by which she is employed, or which she represents will derive a direct monetary gain or suffer a direct monetary loss by reason of her official activity. Any person within the public official's family includes brother, sister, niece, and nephew. A business associate under the code is defined as a person joined together with another person to achieve a common financial objective. Now going into the first question that Ms. Duran posed, can she participate in the same matter that she has participated on 2 different public bodies? That this commission has consistently opined that the code does not prohibit a public official from voting on a matter as a member of one public body and then discussing the same matter and voting on it as a member of another public body. I have listed several advisory opinions on page 5 of the draft. Accordingly, based on those prior advisory opinions, review of the Code of Ethics and the representations of Ms. Duran, it is the opinion of the staff that she will not be prohibited from participating in the proposed, in the council's review of the proposed changes, charter changes, notwithstanding that she has already participated in that matter as a member of the charter committee. This is provided, however, that the petitioner's participation in either of the public roles would not otherwise directly financially impact her or her business associates. So before her as a council member is review of those charter changes. Ms. Duran and her family members own property in the fire district. She does not reside in the home, and she also owns a bathhouse condominium unit. Both of those ownerships currently qualify her as a voter in the fire district. Her family members also either own a property in the fire district or a bathhouse at the beach club. That also, although they don't reside in the fire district, that qualifies them currently as voters in the fire district. Therefore, as a result, if any changes to the voting rights made, their voting rights could be impacted potentially in the future. The Ethics Commission, you might remember, reviewed an advisory opinion that was similar in fact back in 2023. That's advisory opinion 2023-18, and that also involved changes to the fire district charter and the voting franchise. The requester was a state representative, and she asked whether or not she can participate in legislative activities that pertain to an enabling legislation that would allow the fire district to hold a meeting and allow the voters to decide whether or not to make any changes. That petitioner owned a vacation home in the fire district and a bathhouse at the beach club. The commission allowed that petitioner to participate in the legislative activities because the commission determined that her voting rights would not have been impacted. She would have still be allowed to vote. And even if her voting rights were impacted, the commission decided that there is no financial impact associated with a voting right alone. And even if there was a voting right, financial impact associated with someone's voting right, there was intervening events, and the financial impact would not have been direct. It would have been indirect. Here, the situation is similar. Based on those reasons, it is the opinion of the staff that Ms. Duran will not be prohibited from participating in council's discussion and decision-making relative to any changes to the voting rights. Because here, similar to the reasoning in the prior advisory opinion, her activities or official activities will be indirect ultimately rather than direct. 6 years ago, the Ethics Commission also reviewed 4 ethics complaints against members of the fire district. There were also members of the beach club. The commission ultimately determined that those fire district council members were business associates with the beach club. Here, as an owner at the beach club, Ms. Duran will be a business associate with the beach club. However, the beach club does not have voting rights. The voting rights belong to the members of the beach club. Therefore, any official action in any changes made to the voting rights in the fire district would not affect the beach club. Therefore, that would not, being a business associate with the beach club would not prohibit her also from participating in the discussions with regards to the voting rights. For all these reasons, it is the opinion of the staff that the petitioner is not prohibited by the code from participating in fire district council discussions and decision-making relative to the changes to the voting rights in the fire district, notwithstanding that she and several family members own property in the fire district. Lastly, Ms. Duran asked whether or not, what the impact is of her paying that special assessment to the beach club on her ability to participate in the council's discussions and decision-making relative to the change in the voting rights. In prior advisory opinions, the Ethics Commission had required public officials to recuse from participating in pending litigation matters that were likely to financially impact the public officials, their family members, their business associates. Here, the petitioner, her sister, her niece, and her nephew are required to pay the special assessments to be used to the beach club with potential litigation. Such litigation, however, right now, is not pending. And whether or not such litigation would happen, it's hypothetical at this time. Any legal action on the part of the beach club, as I said, is hypothetical, but in the event that the beach club initiates or becomes involved in litigation involving the fire district, the petitioner is encouraged to seek further guidance, as to her ability to participate in the fire district decision making relative to such litigation. However, at this time, the petitioner would not be prohibited from participating in the fire district council's discussion decision making relative to the changes in the voting franchise, and that's regardless of whether she's required to pay those special fees. The petitioner is advised that should any of the circumstances change, to seek further guidance from the Ethics Commission if those circumstances would have any direct financial impact on her family members, business associates, or her employer. I'm happy to answer any questions with regards to the draft, and I can also pinpoint the amendments if you wish.
Let me just ask you about that. The amendments are only gonna be to the paragraphs that describe the ownership interests of her family members,
Correct.
which I saw to be on page 2, paragraph 2, and page 6, paragraph 1, full paragraph.
Correct, and also on page 7. It's bottom page 6, top of page 7. Where the paragraph begins with here, similar to the facts and advisory opinion 2023-18. The petitioner of her family members, except her sister, will not be financially impacted. And following that sentence, I'm proposing to add a sentence that states her sister's right to vote could potentially be impacted by excluding beach club condominium unit owners from the voting franchise in the fire district. However, and then the rest continues as is.
Ms. Duran, you've obviously had an opportunity to review this opinion before today.
Yes.
You worked quite closely with Ms. Papa to get here. Correct. Members of the commissions, anybody have any questions or comments to either Ms. Papa or to Mr. Duran?
Just for, I guess, clarification, as the new guy. When we talk about financial impact and in scenarios like this where Mr. Duran or some other a person is on a board, do we include that board's ability to levy fees or taxes or, or monetary sort of changes to the the charter and those type of things? Are those not included in financial impact, or those indirect? Just if you can help me define
So
it.
it depends what the public body is discussing.
Right.
And the public official's activity has to include a direct financial impact upon her. So if she was discussing, for example, to assess a fee on all beach club condominium owners, then, and that was it. They were not sending it to the General Assembly. The voters in the district were not to vote on it. Then this could be a direct financial impact upon her family members, business associates. So that may be prohibited, although there might be an exception, but that would be considered a direct financial impact. So if there are fees included and she would be impacted, then in those circumstances, she might have to.
But I mean, also, again, not to go down a rabbit hole, but the petitioner's ability to vote, I guess. So one sort of side of it would be the personal financial impact, or to her or a family member. And the other sort of side of the coin I'm thinking of is her role in defining you know, taxes or levies or charges and things like that for them, those bodies, and how they may or may not impact family members that reside there. Just in general, by the way, not specific to Mr. Is that too broad a question?
I think we have, usually we'll take it specifically as to
Specific,
what's
okay.
presented before
Okay.
us. And before
Fair
us, it's just the change in
Okay.
the voting rights.
Well, official activity includes discussion as well as voting.
Correct. I hope that answered the
Learning is
question.
taking.
Any other questions or comments? Is there a motion to approve and issue the advisory opinion as presented by the staff?
I'll make a motion that we approve the advisory opinion as presented by staff with the changes outlined that require to address petitioner's specific family members.
And let me ask you a question on that before we ask for a second, which is, we would be authorizing that change without requiring her to come back before us,
That is correct.
simply to take what we're seeing and to make the necessary amendments to the factual statements.
I'm glad you mentioned that, because would that give her blanket authority to act? And what if the complaint issued subsequently to that?
It doesn't give her blanket authority to act.
Well, then,
We're giving her the authority to act within the scope, of what she has described to us.
yes, but subsequent to her taking action based upon the authority granted here, if we do today. Complaint is filed, now what? Complaint comes back before us, or the petition comes back before us. And how do we reconcile it?
We don't have to reconcile. We only issue one opinion.
Well, again, to me, it seems like a blanket authority here.
Now, we're giving her the authority to make the amendments as represented by her to us, to you.
So what is the urgency now?
Well, I understood that there's some urgency to this advisory opinion. Because of matters before the general, that have to come before the General Assembly. I read that towards the end. That was why I felt, just to add those specific family members and that language to this motion would allow Ms. Papa to do.
Nothing's been codified yet.
Say that again?
Nothing's been codified by the General Assembly.
No,
No, they have to make the recommendation.
They have
to
to make the
General Assembly
recommendation.
As a
I
commission.
understand, I understand. I'm just concerned there's maybe a blanket authority. That's one point of view.
Mr. Rand,
Yes, I just would like to clarify. So the charter committee that was established was done so by Judge Taft Carter to recommend, advise the council to make changes to the charter. Once that charter committee met and formulated those recommendations, of which I was vice chair, we presented those recommendations to the council. Now the council is in a position, of which I am an elected council member, to make a decision whether or not we want to progress any of those recommendations to the General Assembly for enabling legislation. If they agree, then it goes to the voters of the community. So what we're trying to do, or I'm personally trying to do, is ask the question, can I vote as a council member to progress one of these recommendations, or several, it could be more than one, to the next step in the process? That's really what I'm here asking for, considering I was vice chair of the charter committee and I have this potential, or I have a legal assessment upon me for potential litigation.
And so it will be limited in scope.
correct,
She's saying.
she's very limited in
That's
scope.
what the advisory opinion is. It just includes.
Yeah.
My
I
question-
would like to see that actually stated in our vote here.
Modify the motion. I just want to ask a question because it was raised. It's been through the committee. It's now before the council. Not getting into attorney-client privilege questions, have you been given some sense of by when this has to be submitted to the General Assembly, on it this year?
Good question.
I believe it's this month, within the next couple of weeks.
So there's a degree of need to get this done now rather than, say, 3 or 4 weeks from now.
Well, 3 or 4 weeks from now, we'd have to wait till next calendar year.
I just wanted to clarify that. So, Commissioner Rabideau, I believe that Commissioner Ritchie is proposing an amendment to your motion to be more explicit in the authorization we give Ms. Papa to make corrections or amendments rather to her proposed advisory opinion as we are to approve it. Fair statement of what you are proposing?
Chair Jones, if I
Yes.
may, if it will be appropriate, I can read what the changes are. If,
If that would satisfy commissioners, you're okay as long as her authority is. Okay. So that amendment has been proposed to the motion. Do you accept the amendment, Commissioner Revenue? Is there a second to the motion as amended? Second by Commissioner Ritchie. Roll call vote. Commissioner Susie,
Hi.
Commissioner Browner,
Aye.
Commissioner Centarini. You stepped out. He's abstained, sorry. The empty chair doctrine. Commissioner Callahan.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Thank you, Mr. Rand. We appreciate it. Next one on the sign-in sheet is Ms. LaSalle.
Chair Jones, Attorney LaSalle is second on the signing sheet. Ms. O'Donnell, however, needs to attend the funeral and happy to present hers next if.
I'm sure Ms. LaSalle has been very gracious in permitting you to go first.
Thank you.
Ms. O'Donnell is the chairperson of the Bonet Shores Fire District Council. Unlike the previous advisory opinion, she is not a member of the charter committee. She and her spouse own several properties in the fire district. One of the properties is her primary residence where she resides full-time. Her son lives full-time in another property. One of the properties is vacant and the remaining are rent properties. The petitioner represents that she and her spouse also own several condominium units with various sizes at the beach club. Here she seeks guidance from the Ethics Commission regarding whether she may participate in the same matter before the Fire District Council relative to the voting franchise. Given that she and her husband are required to pay the special assessment to the beach club. Here, the same analysis as the previous advisory opinion applies. The fact that she owns property in the fire district would not, it is the opinion of the staff, that would not prohibit her from participating in the fire council's discussions and decision-making relative to the proposed changes of the voting franchise, notwithstanding that she owns the property in the fire district. Here, again, any changes to the voting rights will be indirect and not direct upon her and her spouse and her son as well. Now, with regards to the special fees to be paid to the beach club and be used for any potential litigation. Here, again, a litigation with regards to the voting rights is not pending. We don't know when or if such litigation will be brought by the beach club. And it is the opinion of the staff that Ms. O'Donnell here as well will not be prohibited from participating in the fire district council's discussions and decision-making relative to the proposed changes to the voting franchise, notwithstanding that she is required to pay that special assessment to the beach club. I'm happy to answer any questions you may have.
Ms. O'Donnell, you've had the opportunity to see this opinion for today,
Yes,
and you've talked to Ms. Papa about it.
yes.
Do you have any questions or comments?
No, not at all.
Commissioners, anyone have any question or comment for Ms. Papa or Ms. O'Donnell? Is there a motion to approve and issue the advisory opinion as presented by staff? Motion by Commissioner Luther, is there a second? Second. Second by Commissioner Browner. Any further discussion? Hearing none, roll call vote. Commissioner Susie?
Aye.
Commissioner Browner?
Aye.
Commissioner Callahan? Aye. Commissioner Rabideau?
Aye.
Commissioner Ritchie?
Aye.
Chair votes aye. Thank you very much.
Thank you.
The next item is Faith LaSalle.
This is on the tab B. Ms. LaSalle, again, she's a member of the Bonnet Shores Fire District Council and she is also a member of the Charter Committee. She's currently serving as its chairperson. She owns two homes in the fire district. One of the homes is her primary residence, where she lives with her spouse full-time. And the other, she jointly owns with her brother. The petitioner represents that neither she, her spouse, or her brother owns property in the beach club. Given this set of facts, she requests guidance from the Ethics Commission regarding whether she may participate in the Fire District Council discussions and decision-making relative to the proposed changes of the charter and its voting franchise definition, given that she participated in the charter committee's discussions and recommendation to the Fire District Council regarding the potential changes of the voting franchise. Here again, the same analysis applies as the first advisory opinion. Here, it is the opinion of the staff that the petitioner is not prohibited from participating in Fire District Council's discussions and voting on matters in which she participated as a charter committee member, provided, again, that the petitioner's participation in either role would not have a direct financial impact upon her or her family members. Here, the fact that she owns property in the fire district with her spouse and jointly with her brother would not also prohibit her from participating in the discussions and decision-making relative to amendments to the voting franchise in the fire district. Okay.
Ms. LaSalle, you've had the opportunity to review the opinion ahead of time, correct?
Yes, I have.
And to talk to Attorney Papa about it.
Yes.
Do you have any questions or comments?
Right.
Members of the commission, anybody have any questions, or comments for Ms. LaSalle or Ms. Papa? Hearing none, is there a motion to approve and issue the advisory opinion as presented by the staff? Motion by Commissioner Ritchie, is there a second?
Second.
Second by Commissioner Rabideau. Roll call vote, Commissioner Susie?
Aye.
Commissioner Browner?
Aye.
Commissioner Callahan? Aye. Commissioner Rabideau?
Aye.
Commissioner Ritchie?
Aye.
The chair votes aye. Ms. LaSalle. And the next one is Mr. Girardi, who's appearing by way of Zoom, I believe.
Correct. I'm going to promote Mr. Girardi into the meeting, so stand by, Mr. Girardi. Take a moment. Hey, Mr. Girardi, if you are there, you can make sure that you're unmuted for video and audio. Can you hear us okay?
I can.
And we can hear you too. Thank you very much.
Good morning, Mr. Girardi.
Papa.
Good
Uh,
morning.
This advisory opinion is under tab D in your binders. Mr. Girardi is a member of the Bonnet Shores Fire District Council. He is not a member of the Charter Committee. He represents that he and his spouse own a home in the fire district, but they do not reside there full-time. The petitioner represents that he and his spouse also own a bathhouse condominium unit at the beach club. Additionally, his sister also owns a bathhouse condominium unit at the beach club. He seeks guidance from the Ethics Commission regarding whether he can participate in fire district council's discussions and decision-making relative to the proposed amendments to the voting franchise, given that, he and his family members are required to pay the special assessment. Here, similar to all the other three advisory opinions, the fact that he and his family members own property and do not reside in the fire district would not prohibit them from participating, it would not prohibit him from participating in the fire district discussions and decision-making relative to the changes to the voting franchise. Also, the fact that he's required to pay the fee, the special fee to the beach club would also not prohibit him from participating in the fire district's discussions with regards to the changes in the voting franchise. Again, because there's no pending litigation before the fire district, we don't know if that litigation will ever come to fruition. And as all the other petitioners, he is encouraged to seek further guidance in the event that such litigation does occur in the future. Also, I apologize, I have to make another amendment. This advisory opinion, it's very specific, on page 6. The paragraph that starts with here, similar to the facts in advisory opinion 2023-18. The petitioner and adding or his wife will not be financially impacted by the proposed changes. Because under each of the four scenarios sent to the council for the charter committee, from the charter committee, they would still be allowed to vote as non-resident property owners in the fire district. Adding a sentence here, his sister's right to vote could potentially be impacted by excluding beach club condominium unit owners from the voting franchise in the Bonnet Shores Fire District. However, even if, and then the language continues as is.
Before we move beyond that, do all commissioners understand the amendment she's suggesting? Before we move forward.
I'm happy to answer any questions you may have at this time.
Mr. Girardi, you've seen the advisory opinion before today.
I have.
You've had a chance to go through it with Ms. Papa.
I have multiple times, yes.
And do you have any questions or comments or concerns about the advisory opinion as proposed, as amended?
I do not. It's not dissimilar to the other three individuals.
Correct. Members of the commission, any of you have questions for either Ms. Papa or Mr. Girardi? There being none, is there a motion to approve and issue the advisory opinion as amended? Motion by Commissioner Callahan. Is there a second? Second by Commissioner Browner. Roll call vote, Commissioner Susie,
Aye.
Commissioner Browner,
Aye.
Commissioner Callahan.
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Thank you, Mr. Girardi. Before
Thank
we
you.
move next, I just want to compliment you, Ms. Papa, on your presentations. This was a complex set of problems you put together very understandably. We, I'm sure all appreciate the work you put on these 4 items.
Thank you, I appreciate it.
I'm sure you know more about Bonnet Shores than you wanted to.
I do. And I have never been there, so.
Well, now you have a reason to go.
So much.
Just find somebody with voting rights.
Thank you, I appreciate it.
All right, the
Thanks,
next,
Mr. Girardi.
Thank you.
thank you.
Excuse me, Mr. Chairman.
Yes, please.
If I might, I think it's a point of personal privilege. In observing the proceedings, I was reported as abstaining.
No, it's, I have it on my notes.
Okay,
It's
thank you.
Recusal,
Thank you.
and I will report it out as a recusal.
Okay, thank you,
I had A's here originally, now they're all R's.
thank you.
The next one on the sign-in sheet is Sean Brown. Morning, Mr. Brown.
Good morning. Good morning, everyone. The draft for this petitioner is at tab F in your binders. Welcome, Mr. Brown. The petitioner is the town administrator, of the town of Middletown. He was appointed to that position by the town council. He identifies among his public duties the following: the oversight of municipal operations, the implementation of town council policies, and the management of the town's budget, personnel, and public services. In his private capacity, the petitioner is the trustee and sole beneficiary of a trust that was established by his mother, who was recently deceased. The trust assets include a piece of property located on Green End Avenue in Middletown, where his mother previously resided. The petitioner recently received notice that the owner of a piece of property located on Harvey Road that abuts the property on Green End Avenue has applied for a special use permit for an owner-occupied short-term rental. A hearing on that application is expected to take place before the Middletown Zoning Board in the near future. Because the petitioner is the trustee and the sole beneficiary of the trust that owns the Green End property, he would like to participate at that hearing. He explains that in order to maintain separation between his professional role in the town and this matter, which involves him personally, he has retained legal counsel to represent him before the zoning board. The petitioner explains that the zoning board operates independently of his office as the town administrator. The petitioner does not appoint members to the zoning board. Members of the zoning board do not report to him, and he has no supervisory authority over the zoning board or its members. Mr. Brown seeks this advisory opinion regarding whether he is prohibited from appearing in his private capacity before the Middletown Zoning Board in response to the application for a special use permit filed by the owner of the property that abuts the trust property. The applicable provisions of the Code of Ethics are section 3614(5)(e) and Commission Regulation 1.1.4. Under these provisions, a public official or employee may not represent himself or authorize another person to appear on his behalf before a state or municipal agency of which he is a member, by which he is employed, or for which he is the appointing authority. Representation is defined as participating in the presentation of evidence or arguments before that agency for the purpose of influencing the judgment of that agency in his own favor. While many conflicts can be avoided under the Code of Ethics by recusing from participating and voting on certain matters, such recusal is insufficient to avoid this particular prohibition. These particular prohibitions continue while a public official remains in office and for a period of 1 year thereafter. Here, Mr. Brown is not a member of the zoning board. He is not employed by the zoning board. He is not the appointing authority of the zoning board. For these reasons, the cited provisions of the code do not apply. Accordingly, it is the opinion of staff that the petitioner is not prohibited from appearing in his private capacity, either personally or through an authorized representative, before the zoning board in response to the application for a special use permit filed by the owner of the property that abuts the property held by the trust for which Mr. Brown is the trustee and the sole beneficiary. I'm happy to answer your questions or to defer to Mr. Brown as you see fit.
Morning, Mr. Brown.
Good morning.
You've had an opportunity to review this advisory opinion before today,
I,
and you've gone through it with Ms. Papa.
yes,
I'm sorry, Judicious.
yes,
I went through it with Ms. Brown.
Glad to hear it. Do you have any questions, concerns, comments to the commission?
I know.
Members of the commission, does anybody have, Commissioner Rabideau?
Yeah, I guess I have a question. Does the zoning board have a budget specific to them? I mean, I'm assuming you have a planning department and they have a budget, but does the zoning board itself have a specific budget that you may have influence over?
No.
Thank you.
Anyone else? I have just one question. It's sort of related to conversations we've been having here, but I'd like to know your property, which you describe as abutting the property where the proposed special use permit is going to be. Is that an immediate boundary to boundary connection, or is it a 200-foot
It's immediate,
immediate?
yes.
Thank you. Any other questions or comments? Is there a motion to approve and issue the advisory opinion as presented by staff.
So moved.
Motion by Commissioner Rabideau, is there a second? Second by Commissioner Susie, a roll call vote. Commissioner Susie? Commissioner Browner?
Aye.
Commissioner Celerini?
Aye.
Commissioner Callahan?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Ritchie?
Aye.
The chair votes aye. Thank you, Mr. Brown. Appreciate you coming in.
Appreciate your time.
The last item is Cynthia Roberts.
Yes, the draft for this petitioner is at tab E, and Ms. Roberts sends her apologies. She's out of state today, but she didn't want to hold us up and has asked that you proceed in her absence. Petitioner is a dual public servant in the town of North Smithfield. She's a member of the Planning Board and a member of the Groundwater Protection Committee, or the GPC. She seeks guidance from the Ethics Commission regarding whether she is prohibited by the Code of Ethics from participating as a member of both municipal agencies' discussions and recommendations to the North Smithfield Town Council concerning an application for a mining overlay district that is currently pending before the Town Council. As a member of the Planning Board, the petitioner would be tasked with reviewing the application for the mining overlay district and then making a recommendation to the Town Council regarding how the proposed overlay district aligns with the town's comprehensive plan. As a member of the GPC, the petitioner would be tasked with considering how the proposed mining overlay district might affect local drinking water safety and then advise the Town Council accordingly. Ultimately, it is the Town Council who will decide whether to allow the mining overlay district. Importantly, neither the petitioner nor any of her family members, business associates, or her employer stand to be directly financially impacted by any planning board or GPC decisions relative to this application. The petitioner would like to participate in the evaluations of the application by both the planning board and the GPC, provided that she may do so in conformance with the code. Under the Code of Ethics, a public official may not participate in any matter in which she has an interest that is in substantial conflict with the proper discharge of her duties in the public interest. That's under section 3614(5)(a). A substantial conflict of interest exists if a public official has reason to believe or expect that she, any person within her family, her business associate, or any business by which she is employed or which she represents will derive a direct monetary gain or even suffer a direct monetary loss by reason of her official activity. That definition of substantial conflict of interest comes from section 3614(7)(a). Additionally, a public official may not use her public office or confidential information received through her public office to obtain financial gain for that same quartet: self, family member, business associate, any business by which she is employed or which she represents. A business associate is defined as a person joined together with another person to achieve a common financial objective. And a person is defined as an individual or a business entity. The Ethics Commission has indicated that the code does not consider a public body to be a business, or the relationship between a public official and a public body to be that of business associates. The Ethics Commission has also consistently opined that a public official is not prohibited from voting on a matter as a member of one public agency and then voting on the same matter as a member of another public agency, provided that the aforementioned provisions of the code are not otherwise implicated. Two advisory opinions that support this appear on page 3 of the draft. Here, the petitioner is not a business associate of either the planning board or the GPC. She will be participating in her public capacity as a member of each of those agencies in the consideration of the mining overlay district application. For purposes of then providing advice to the town council prior to the town council's rendering of a decision on that particular application. Additionally, the petitioner represents that neither she nor any of her family members, business associates, or her employer stand to be directly financially impacted by any planning board or GPC decisions relative to the application. Accordingly, based on the petitioner's representations, the applicable provisions of the Code of Ethics and prior advisory opinions issued, it is the opinion of staff that the petitioner is not prohibited from participating as a member of both the planning board and the GPC in discussions and recommendations to the town council concerning the application for a mining overlay district. I'm happy to answer your questions.
I'll open it up to the members of the commission. Question for Ms. Radicious? I do. You represented here that she has represented to you that her family will not be affected, as I understand it, by the creation of the mining district overlay district, correct?
My understanding is the representation that her family will not be directly financially impacted by her official action in this particular matter.
All right, so limited to that, she's not the one actually adopting the overlay district, so it doesn't mean the property is within that district? Is that what you're saying?
Essentially, yes.
Because that was my concern here, is all it says, the general representation, they won't be affected, but if their property is within the mining district. We've just talked about property effect before, but that gives me some concern. And that isn't really related to it here, but if you're saying that doesn't matter because the decision she's making is simply to send something on to the council, then I get that.
Well, the GPC is absolutely advisory only, and I understand the planning board and the GPC is to, talk about the drinking water. The planning board has to advise as to how it fits in with the comprehensive plan.
But it's still only advice.
Pardon?
It's still only advice. It's still only a recommendation.
Yes,
Okay.
and of course, advisory opinions are based on representations of the petitioner. To the extent that for any reason, which I'm sure would be inadvertent in Ms. Roberts' case, it were not factually accurate, then the advisory opinion would not come to the protection that she seeks from it.
You answered my questions.
Thank you.
Anyone else have questions, comments? Is there a motion to approve and issue the advisory opinion as presented by the staff?
So moved.
Motion by Commissioner Rabideau, I think it was a second by Commissioner Callahan. Any further discussion or comment? Hearing none, roll call vote, Commissioner Susie.
Aye.
Commissioner Browner.
Aye.
Commissioner Centarini. Commissioner Callahan.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. Thank you. Now, Mr. Grammett presented during the director's report a suggestion that on item 6, we simply pass the matter off the calendar subject to coming back on the next time. Item 6 was continuing discussion of potential rulemaking, amending the Code of Ethics gift rule at 520-RICR-00-00-1.4.2 to apply to gifts from all registered lobbyists. That was being presented by Director Grammett and came from Common Cause. Is there any objection to postponing this for a further date, passing it off the calendar as suggested?
Can I just ask for clarification? The last time we considered this, I perceived that Common Cause had verbally amended or stated that they weren't on the inclusion as lobbyists as a class. I believe he said that, so should that be reflected in the summary of the next topic item? And I asked the chair's guidance.
I don't think so. I think an agenda item is general. I think that's what we have here was continuing discussion. I think what you're perhaps suggesting would be something that might end up in minutes. In my way of thinking. It's, if you're talking about what he has done in terms of reducing what he's look at, then that's not something that would show up in an agenda. It would show up in minutes. But that said, my understanding, and maybe we have it, is that he was going to submit an amended proposed rule, and I assume he would take care of that context. Is that your understanding?
Yes, he has submitted a amendment to his initial, which was more of a broad-based. The initial proposal was, let's include gifts from all lobbyists to anyone covered under the code of ethics. And now my understanding is, based on what he submitted previously at the last meeting, was that it's still from all registered lobbyists, but only as to those public officials that lobbyist is lobbying.
Right.
Right, so it did narrow it quite a bit.
I don't, because it's rulemaking though, Commissioner Henry, I don't think it's like a finding or an admission, but please feel free to.
No, I
make your point.
thought he was also limiting his request at this time to nonprofits.
You're right, there was discussion of
And he submitted. a
maybe
written
taking
amendment.
government lobbyists out of it. But there's still more work to do. As far as if you're talking about changing what the agenda item says, it's six to reflect it. I would say that there, agendas are more of an art than a science, I think.
I'm just asking guidance, my chair, I think the executive director.
I think your point is well taken in terms of what he did and what's before, so they'll come out in the context of the rulemaking process, should we decide to go forward with it. Because we'll eventually be looking at a particular rule, I would think, that would address those concerns. I agree with Mr. Grammett that it's an appropriate agenda as is. So I'll go back to my question, which is there any objection to postponing this matter till at least our next hearing date or meeting date? We have a consensus that that's an acceptable outcome for today. I think we will continue this matter to another date. I'm not sure what the distinction between passing it off the calendar and continuing it is. But as far as I'm concerned, it comes back up, as you pointed out in your executive director's statement, that it's always on the agenda, rotating down. So with that understanding, I'm fine with that. Is there a motion to go into executive session to wit? A motion to approve minutes of the executive session held on March 25, 2025. Pursuant to our Gen Law, section 42-46-5, A, 2, and 4. And then to take up In re Heidi Weston Rogers, complaint number 2024-12, pursuant to our Gen Law, section 42-46-5, A, 2, and 4. And then a motion to return to open session. Is there such a motion? Moved by Commissioner Ritchie. Is there a second? Second. Seconded by Commissioner Browner. Roll call vote, Commissioner Susie.
Aye.
Mr. Browner.
Aye.
Commissioner Centerini.
Aye.
Callahan.
Abstain minutes.
You would not.
No, we're just,
This is merely the motion.
Just the
in the
minutes.
session.
just get going to the executive session.
We're going to discuss the agenda. So thank you. Gotcha.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Thank you. We'll go into executive session now.